So, here's something that you really need to know about when you make that decision to send the case out to an attorney. In New York, the attorney's fees in a medical malpractice case are dramatically different than in a negligence case. So, for those of you who don't know, in a car accident case, in a dog bite case, a trip and fall, those cases, the attorney's fee after the expenses are repaid to the law firm is 1/3. 1/3. So typically, if you refer a personal injury case to a PI attorney, they will give you 1/3 after their expenses of their own attorney's fee. In a malpractice case, the fees are dramatically different. Malpractice cases only start, and they have what's called a sliding scale. So the fees after expenses are reimbursed, it starts at 30% and drops by 5% as we get more and more money. So to give you an example, if we get anywhere from $1 to $250,000, the fee for that segment is only 30%. If we get anywhere from $250,000 to $500,000, the fee then drops to 25%. If we get anywhere from $500,000 to $1 million, the fee for that is 20%. And it continues to drop until we reach a ceiling of $1.25 million. Anything above that, the lawyer's fee is only 10%. So let me give you an example. 2 weeks ago, I settled a case involving a wrongful death, involving a hernia repair where a hole was made in the bowel. And it was unrecognized. The patient ultimately died because they failed to recognize, what's the word? Sepsis, causing a massive infection, causing a death that was not recognized until the autopsy was done. And just in this scenario, what happened was the doctors recognized the hole in the bowel during surgery. Recognized it. The problem arose when the doctor now made a judgment call, and what he did was, in our opinion, a departure from good care. He was a GYN cancer surgeon. We argued that he should have called in a bowel surgeon or a colorectal surgeon or a general surgeon to come in and repair that bowel. Instead, his team opted to do it on their own. And when you have an injury involving a bowel, if it's a significant one, you have to remove and cut out the damaged portion of the bowel. But then you're left with two ends that are open. You have to connect the two together and then sew it up tight to form a watertight seal. That's known as an end-to-end anastomosis. Well, we argued in this scenario that the doctor and his team didn't do it right, because when the surgeon 2 days later, went back in to evaluate, once they opened the belly, what he found was astonishing. He found that the fecal contents from inside the intestines were in her abdominal cavity where it never should have been. And that's why she was getting sicker and sicker, and nobody recognized it. And more importantly, that bowel that was supposed to be closed together with a watertight seal was wide open. That's where everything was coming from. She died shortly after, a few hours later. And I settled that case 2 weeks ago during mediation for $840,000. Now, the attorney's fee on that particular case was 24.5%. So if you were to have sent that case to me as a referral, what happens then is you would get a percentage of the percentage that I recovered. So if I got 24.5%, you would get 24.5% of what I was able to recover. Okay? If I was able to recover 20%, you would then get 20% of what I was able to recover. So if you make that decision to send a case out to a referring attorney, you must get confirmation of that in writing. Always, always, always. As attorneys, you know that, but most of you do not do that. Make sure that confirmation with your referring attorney is in writing, and the good attorneys will gladly do that. Now, the next thing you need to know is once you've made that decision to refer the case out, you are required to fill out a retainer statement and file it with the Office of Court Administration. It's known as an OCA retainer. And it basically says, I retained Mrs. Jones on this date, and I referred the case to Mr. Oginski. And this way, it will permit you to receive a referral fee at the end of the case if we are successful. Otherwise, if you fail to prepare a retainer statement, there is no way that you can ever justify getting a referral fee because you failed to follow the court rules.